All right, the Public Defender Services Corporation Board of Trustees meeting will be called to order. Notice of the meeting was published and October 17th and 20th. And will the secretary please call roll?
Chief, this is Robert J. Torres.
I'm present.
Presiding Judge Alberto C. Lamarana III.
I'm present.
Guam Bar President Jackie T. Terlahi.
She's not currently with us, but we expect her to be joining.
Trustee Donna Muñoz Canata.
I'm here coming from Seoul, Korea.
Trustee Christiana Whitman.
Present.
Anaseo Donna Kanata.
Thank you, sir.
All right.
I'm trying to mute this now.
We do have a quorum. 4 of the 5 members are present. First matter is the approval of the minutes from the regularly scheduled meeting of October 3rd. Is there a motion to approve the minutes?
Motion.
Go ahead.
Moved and seconded. All those in favor say aye.
Aye.
The meeting minutes are approved. There is one, I'm sorry, I meant to point out one thing on the meeting minutes that let me go back and pull that up real quickly. Just too much in a rush. Hang on, give me 1 second. And I'll go back to the meeting minutes that I had one comment on the minutes that was there. And this was, I just wanted to confirm that on page, and this was a question that will come up later in our meeting, on page 9 of 70 in the meeting minutes, it says that Executive Director Hattori in the first full paragraph commented that he talked with DOA and that their study had been completed and just needed to be signed and transmitted to the governor's office. I don't recall that, and I might have missed it when it was mentioned, but is that accurate?
Your Honor, I went ahead and corrected that and sent out an updated packet this morning. So if you see on screen, we removed that. I did talk with DOA the same day as the meeting, and I just put what they told me, and that we corrected that already. So an updated packet was provided to the board members. So if you could see on the screen, we pulled that out.
Okay. All right. Okay, I see you made the correction there. I missed the updated packet. So, all right, fine. So the minutes then with these updated minutes that were submitted are the minutes that we've been approved by that motion, second, and vote. All right, we'll now go to the next item on the agenda, and we'll run through I don't know if there's any new business that needs to be, old business that needs to be reported, but we'll go through them anyways in terms of, since our last meeting 3 weeks ago on the financial status update or the allotment releases.
Your Honor, I'll provide the update for PDSC and APD and the rest of the group. So PDSC and APD, we received $302,801 as of October 11th from our requested allotments, bringing our request to 46%. But please note that we get our allotments with every pay period. So by the time this week ends, we'll be up to 91%. So we'll get our full allotment from DOA. In terms of STOP and the Improving Criminal Justice Response Grant, STOP 21 has a balance of $1.94, and that will be returned to the federal programs, GCO, FPO. Any additional funding that will be required for STOP, which is the Advocacy Center, will come from the ICJR grant. As of 9/30, the balance for ICJR is $54,008, and that covers personnel costs as well as travel and supplies. This funding will be used until STOP 22 comes in from the governor's office. Regarding the Elder Justice Center for FY 2023, as of today, we received full payments invoice from October 2022 to August 2023. We're just waiting for the invoice that we submitted for September. that remains outstanding, and that amount is $20,768. As for the Burns JAG grant, a final quarterly report together with an invoice for expenditures from July to September 2023 has been delivered to BSP. That will close out this grant that we received from BSP for access to counsel. That's all I have, Your Honor.
All right, thank you. Any questions from Kathy about the financial status update? If not, we'll go to the ED's report. Steve?
All right, thank you, Chief Justice. The only thing I really wanted to report was we provided our stats last week. We're also revising them to try to figure out how many cases we actually resolved, moved from pre to post in the last fiscal year. So we'll have that at the next one. We did have that 3-day conference. We really appreciate the participation of the speaker, Justice Carbolito. Unfortunately, you weren't able to be present. Jay Ariola moderated, and we had the speaker was present. It was actually a really good discussion. I think the employees really appreciated hearing from them. We also had David Carroll from the Sixth Amendment Center. He zoomed in and didn't really give an update about the report they're working on, but just talked about the general principles behind the Sixth Amendment. And so, we really want to thank the judiciary for kind of rescheduling some court hearings so that our attorneys were able to attend. I think, we got a lot out of it. It's kind of funny because we had a whole session on geofence warrants, and apparently that's going to be a topic for the Pacific Judicial Council one.
Yes. In fact, we have one of the national experts from the National Judicial College, and also teaches at the for the feds at their Alabama Center, who will be talking about this at the upcoming conference. So it's definitely going to be a very good conference. All right. Anything else, Steve? Any questions from Steve? If not, we'll go to Annie on the APD.
Good morning, Your Honor. We don't have really anything to update. So thank you again, though, to the judiciary for allowing us to do the conference. I do note that a former APD attorney, Jamie Spivey, has passed away last week. We'll let the board know if we do any type of memorial service for him. That's it. Thank you, Your Honor.
All right, thank you, Annie. And Carol from Civil Law Center.
Nothing new to report. And thanks again for also clearing the calendar so we could be in attendance as well. At the next board meeting, hopefully I'll update you on what we're doing to do like a proposed, I guess, priority and goals and objectives for each of the programs in our in Civil Law Center. And then we'll provide that to you guys so that we can discuss whether we can get input from like the bar and the community as well.
All right, thank you. Now on the client income guidelines, Steve, I see that we did send out the surveyor to the Guam bar, right? And we got some comments. Hello?
We sent it out, but I think we sent it out like the day before the typhoon. So we really only had 10 responses. And
Okay.
so we summarized them and we added them all to the board packet. And
Right, I saw that. I didn't have time to go through all of them and decipher it. Was there anything that would be helpful in terms of recommendations that were contained in there?
Well, it's kind of hard to say. There were some that were concerned that that we should consult the taxpayers, but when it comes to constitutional right, I don't I don't know if that's something how we would do that. I mean, most of them seem to, well, first, like 99% of the bar didn't submit any comments. There were 10 surveys completed. Out of that 10, it was like maybe 70% said we need to increase it, and then there was some dispute as to the specific proposals. But it seemed like if it's really up to this board to decide which what the income guidelines should be, and then we can work out those other conditions or like guidelines maybe at a later date and get more bar input on that. I mean, there's been there really hasn't been a case that's gone up to the Supreme Court as to what it means to be indigent. But, there is that the Puerto Rico case where they said, Guam is not Puerto Rico is a single jurisdiction, right? So there isn't any independent adequate state grounds that they can use to change, basically federal law, right? So on Guam, if we follow federal law, they really don't even have it's basically a net income based approach, which we're not sure if the bar really would support that. But
I think there was one comment, if I recall, that discussed the net income approach that was there. But I didn't have time, unfortunately, to go through all of the comments before today's meeting. And so I was just wondering if there were any suggested recommendations to or amendments to the proposed guidelines. I mean, obviously, they are just guidelines. The ultimate decision rests in the discretion of, as far as appointment, for with the trial judge or the appointing judge that's there. But I thought I had saw when I only skimmed a few, that there were a couple of things where there were recommendations made or suggested amendments, but I might have been mistaken. I don't know if someone has gone through it thoroughly and just considered whether any of those comments were worth incorporating or not. That's all my question is.
Yeah, I mean, I think some of the comments were like we should use 100% of the federal poverty guidelines, but under those guys, not even SNAP uses 100%. They use like 150% of the income guidelines.
All right.
And
well,
so,
I mean, I don't have a problem going forward and looking to update the guidelines currently. And there is a resolution that's attached accomplishing that.
Steve, are we
questions?
Are we ready to approve the recommendations, or shall we defer to one more meeting?
Well, I mean, if we could, let me see does the resolution just approve the income guidelines, then we can work on the other guidelines.
It approves the updated eligibility guidelines on attachment A.
Oh yeah, that will be fine, and then we'll work on any other proposed changes, and I mean, a lot of these really we need to work out with. I think that's going to require rules changes with the miscellaneous rules, and the might touch upon magistrate judges, like an appeals process, and how there's a supplemental affidavit that they would have to submit explaining, what their expenses are and things like that.
So what is the public defender executive director's position? Is he looking for the board's approval of these eligibility guidelines now as amended, updated?
Yes, Chief Justice, if we can get that, and then just the table and the if we can just have that approved, and all those other guidelines, the supplemental ones, will iron out, and then we'll submit another survey to the bar and get further input on those.
Okay,
So
I make a motion to approve the eligibility guidelines as recommended by
Second,
the executive director.
All right, it's been moved, and Donna doesn't even wait for PJ to finish. She's already second.
I know.
sorry, sorry.
quick.
'cause-
You're quick,
Donna,
Donna.
you're in
quick.
my quorum.
He
You're
wants,
already
he wants to make sure Christiana doesn't get the second.
I can't even press my my unmute button.
It's like Jeopardy, she's the first one there. All right, it's been moved and seconded. All those in favor say aye.
Aye.
There being no objection, the eligibility guidelines are updated and approved in accordance with the resolution. The next item under old business is the attorney pay plan, and everyone's had an opportunity to read, I hope, the memo that was prepared by John Morrison for the board in response to the question that was raised by Attorney Terlahi about the authority and whether there was any limiting language in light of the legislature's requirement that a pay study be done on implementing the increases. I did have a couple of questions on the, I wanted to be, just to be clear upon. In John's memo, the first item is he mentions that the amount that was submitted and was approved, or that was transmitted to the floor on the budget, the amount of, I think it was, let me just find it, I had it highlighted here a second. The amount was the 7,872,834. At the last meeting, Steve, you had mentioned that when they were debating this 15% and required the pay adjustment, that they reduced our budget on the floor to account for that. But John's memo seems to indicate they did not at all change the amount of the budget that was submitted. Can you clarify that for me?
So Chief Justice, yeah, that's correct. So when the bill was reported out of the committee on the Appropriations Committee, it had already included a reduced amount, and it also had the proposed amendment for that specialty pay. So they didn't on the
What do you mean it was a reduced amount, taking out the 15% with the idea that the amendment for the specialty pay would bump it up? Was there a separate allocation for that?
No, there was no, they didn't explain why they reduced it, other than we do have some unexpended appropriations, so that they wanted us to rely on, but they never said we're reducing this because we're not gonna, otherwise they wouldn't have included the amendment to the bill. So that when the bill was reported out of committee, it had both the amount that we eventually were appropriated and the amendment authorizing the specialty pay. And so when the amendment to remove the specialty pay provision went through, there was no corresponding de-appropriation of the 15% from our budget, which is, I think, the point John was trying to make, John.
Yeah, just so we're all clear on it, what we submitted to in our budget was reduced by the time we were dealing with OFB. We didn't have a public hearing this time, but the numbers that OFB had with us when they sat down with us was, I believe, the 7 million that we're talking about. And Steve Barrera was satisfied that with our continuing appropriation and this amount, that would get us through the year, and was very supportive with us when we had our meeting of the 15%, basically saying that if the bill 3337 hadn't been approved yet, this would be a sort of a catch-all provision, but there was no discussion about reducing or circling back to reduce if that amount got cut. It was just, this is the lump sum. It'll get us through this year, even if we include the 15% for attorney pay. So we didn't have the benefit of a public hearing, unfortunately, but there was no effort by the legislature to circle back and trim off 15% from the budget once they knew that.
All right, and I understand that. It was a little bit different than how I think it was explained at the last meeting. So I appreciate that clarification. I was left with the impression that the amount that OFB had proposed in the budget and was being discussed on the floor was reduced when they eliminated the miscellaneous provision by 15%. And you're saying that was not how it happened, and they never went back, and what was submitted for debate on the budget bill was not changed at all in terms of the total appropriation to PDSC, even with the elimination of the 15%.
I believe that's an accurate history. Steve, correct me if I'm wrong.
That's correct.
That's what I want to make sure, because Steve indicated last time he thought that that amount was reduced when the miscellaneous provision was acted upon. And I didn't go back, huh?
I think he may, I don't want to tell him what he may have meant, but I think he may have meant that it was reduced from what we initially submitted in our packet. We didn't get everything that we asked for. We never do.
Yeah, well, of course, no one, I mean, OFB always reduces the amount, but I'm more concerned about the amount that was originally advanced by OFB and whether there was any adjustment to that amount on the floor by the legislature of the budget.
There was not.
Okay, all right. And that I think that clarifies from the last time, because that was also a concern. If the legislature had actually gone in and reduced the OFB advanced budget by an amount that was, comparable when they were debating the miscellaneous provision, I think it would be a clear indication of legislative intent for what they wanted to do, to postpone the pay increase until the time that the pay study was done. And then the next question, it seems to me, and I went back when I was reading the fact that there was an amendment that Senator Kanata submitted that authorized a 6% pay increase. And so clearly the senators all voted in favor of that, and it allocates it. And in fact, the language of the term is that the public defender shall allocate a 6% increase in compensation for attorneys who work for the public defender and the APD from the appropriations made in this act. So clearly, they had no qualms about doing an additional 6% above the 6% that was authorized last year, because they went ahead and seemed to authorize that by this miscellaneous provision that passed, John, as you pointed out, right?
Yeah,
So,
I think that's fair. I can't unfortunately get in their heads and know what they would have done if one or two things had gone differently. But I mean, there was support for this 6%. I think from both people that were favorable to the 15 and people that had problems with it. And
right.
The people that were supportive of the 6% and were supportive of the 15% viewed this as sort of a band-aid, that at least we can get the public defender attorneys something for this period of time, although it's not everything we wish we had support for right here on the floor. So there were a number of discussions that were going on.
And of course, I think, as in retrospect, as we go back and look, recognizing, I don't think there's any dispute that, and in fact, the legislature as well recognized the authority under the statute for the Public Defender Service Corporation Board of Trustees to make pay adjustments in accordance with 4 GCA 6302B. So I don't think there's any question that was there. But so again, I guess the question is, when we went in for the miscellaneous provision that looked for the 15%, we did not need that authority to just go forward on the 15%. But presumably it was because there was an effort to try to make retroactive pay go back to the beginning of the fiscal year to match the Attorney General pay. Is that correct?
That's absolutely accurate. It would have been legally problematic, impossible for us to get the board to approve retro pay. We wouldn't.
Oh no, we would not be able to approve it without statutory authority, and so
this was an attempt by everyone to try to get true parity back from when things sort of went the rails.
And obviously, now, I mean, you're not going to get any sort of retroactivity, and so exercising the authority that we have. What I'm in light of the approval of the 6% already, or a mandate from the legislature that we have to allocate, its mandatory language, we allocate 6% to compensation for attorneys, a 6% increase. I think we can go ahead and clearly approve that 6% increase now. And that would be on top of the increase that occurred last year. Obviously, it's not the full 15% that's here, but what I would suggest on the additional amount, and I'm just, this is for, and we can pull up the resolution and maybe make a motion to approve the resolution for discussion purposes now, if someone would do so.
I can motion it if you like.
All right, thank you, Trustee Kanats. Is there a second on the motion for discussion purposes, please?
I'll second the
I
motion.
oh, yes.
All right, it's been seconded by the presiding judge. What I was thinking about, I mean, clearly the legislature has no issues with the 6%. They mandated that the pay study be done by the Department of Administration. I'm thinking that a way in which we can recognize the legislature's desire to get the pay study completed is that we could consider as an option that the pay study, the additional amount beyond the 6%, which would be the 9% presumably, because the 6% can go into effect now without any restrictions or any contingencies. But we could also make the other adjustment go into effect, the additional 9%. And this is just something I was thinking about immediately as well, unless the legislature disapproves the adjustment through legislation that's enacted within 30 days from the date of the resolution. And that way we, give some deference to the legislature. I really think we made a mistake going to the legislature with this 15% retroactive. We should have just been satisfied and adopted that pay adjustment from the beginning. And if I think if you had consulted the presiding judge and I beforehand, I think we might have cautioned against that because it did open us up to scrutiny when we didn't need it. And I think we were, we probably should never have gone forward, recognizing that we have that authority now. As I said the last time, I don't think in looking at John's memo that they put in any restrictive authority or made necessarily our ability to pass that, but it's clear from, I think, the debate and from the discussion and the passage of the resolution, which was a compromise from Senator Kanata on the 6%, that the full 15% not go into effect until the pay study would be completed. But of course, I recognize the need to get compensation to be competitive with the rest of the government of Guam. And in the second whereas clause where we talk about pay disparity existing between public defenders and prosecutors, I think it's broader than that. And I don't think the focus should be just on the prosecution. And it exists between public defenders and other government workers that reflects inequality in compensation and impacts their ability to hire and retain lawyers. So if someone would make a motion to on that whereas clause, I think it would be worth looking at, because I don't think we're not only talking public defenders and prosecutors, we're talking about public defenders and other attorneys within the government of Guam system. We know what, being competitive with what the Guam Power Authority, the Port Authority, also with the judiciary's attorneys, and the public defender is not on par with those lawyers throughout the government. And of course, the statute requires internal competitiveness. Internal equity and external competitiveness, and internally, the public defender employees have received the benefit of the general pay plan increase and the law enforcement increase. So there, and as the presentation that Kathy has put forth before and is in the packet today shows that. So, and that's something I'm just tossing out there for discussion, in terms of, looking at that as an option where we've at least given some deference to the legislature and what they've looked at, recognizing that, it's, while we stand on our statutory authority, I think this will be, have a way of the legislature at least weighing in if there's any pushback on the raise, on the full amount without the completion of the pay study. It was my hope that the pay study would have been done immediately. And when I read the minutes, which was since corrected, that pay study was done and was just waiting signature, I thought we could push for that, and I pushed the administration to try to get that out, because there is a detrimental impact to the PDs if we fail to act on their pay. I mean, they are seeing attorneys leave. They saw one leave recently to private practice, and I think it's only going to make it more difficult for recruiting, unless we're competitive, and the scales show that PD's at the bottom of the realm, amongst other public defenders across the country.
So, Your Honor, I have a question. Can you hear me?
Yes, we can hear you.
So on the motion, we're gonna stick the 15% in? Because I think that's where I wanted it to go, right? Or that's where we'd like it to go.
Yeah.
So do we have to stick?
Yeah. The first thing is on the second, whereas I was hoping that we'd entertain a motion to change so that discussing the disparity existing between I don't want it to be a public defender versus prosecution debate. I don't think that's helpful. I think it's more than just public defenders and prosecutors. Of course, there's all the reasons that and have been discussed about public defenders and prosecutors having parity and having comparable pay, but it's to me it's more than just that. So that's the first thing. And then on the second item, because of the way in which, and I think really it was of our own making, unfortunately, because of the fact that we went into the legislature seeking the 15% when we had the authority to do it, but with the hope of the retroactivity, and we did not get that from them, and with the requirement of the pay study be completed, that we approved the 6% now, also approved the 9% for the total of the 15%, but the 9% would be subject to the language that I would suggest would be that it would be effective now, but if the legislature decides or disapproves of our adjustment through legislation that's enacted within 30 days, so it would go into effect today unless the legislature disapproves it. So it would take a vote of 8 to pass a bill disapproving of the additional 9%. And that has to be done within 30 days from the date of the resolution. And that way it at least recognizes and pays some deference to what the legislature did when they acted before. And if they don't do that, then obviously the pay increase remains in effect. If they do pass a bill, the governor would still have to sign the bill. And I'm not sure she will, but I've not talked with her about this, but it would have to go to her. And if it isn't signed and would be vetoed, the legislature would have to pass it by 10 votes in order to rescind the 9% until the completion of the pay study.
So Your Honor, just for conversation, What if we just went in with the whole 15%?
Without
I-
any restrictions?
Without any restrictions?
Yeah, I mean, and that's an option as well. My concern with that is whether there will be any political outfall from us going forward when they've allocated the 6% already from our appropriations by the miscellaneous provision and required the implementation of a pay study when they were debating the 15% at the onset. And so, you know, that I mean, I think we have to be prepared for potential political outfall if we just go in with the 15% in its entirety. We still would be doing the 15%, but it would be recognizing that the legislature would at least have a say on whether that would remain pending the completion of the pay study. And I think we're only in this position because of the fact that we put ourselves out there to the legislature with that miscellaneous provision, and we didn't need to.
And actually, you know, I'll take the blame for that. The legislature is the one that created this problem when at 11 o'clock at night they passed a specialty pay for prosecutors and did not include us. And so we thought, let's have the legislature fix the problem. They decided not to fix the problem, so we're asking, you know, the board to correct it. And I mean, the legislature, they have political concerns about supporting public defense. And you know, I mean, we all know about all the threats that were made by the Attorney General. But I don't think this board has those same problems. And really, we're the last ones to the table at this point. We're
Steve,
98% of Guam got raises already. Sorry.
So for me, can you guys hear me? I'm so sorry. I just wanted to add that if sir, I know what you mean about, you know, the way we present it, but I really think we should just try for the 15%. Just go for it. I mean, we just lost a young attorney and there was a resume for another attorney to come on, but I think to attract good attorneys to the public defender, we need to make sure that we want to pay them for what they're worth. So, I mean, for me, it would be, I would go on with the 15%. I respect where you're coming from and I respect them, but you know, for me, you're right. We didn't have to tell them, we told them, but I think we should just still go ahead and go with the 15%. That's where I'm coming from, because I think these attorneys deserve it. And you're right, we are at the bottom. I mean, public defenders is at the bottom of the list when it comes out to pay. I mean, let's say we don't compare it to the AGs, but we compare it to all the other agencies, we are getting the least pay. So I would just want to go with the 15%, sir. That's just I hope somebody else agrees with me, but that's where I want to go with this.
Your Honor, I've been in text messages with the Guam Bar President, Jackie Terlahi, and she also wants to vote 15%. She's showing me she's still in traffic. She's in LA, but she says here in a text message that I want our PDSC attorneys getting the 15%. And she asked, do we need a written proxy for her vote? This is from Jackie Terlahi. So she also, and she's hoping that maybe Donna or Christiana will make that motion. But she's in full support of the 15% for the attorneys.
Okay.
I mean, if it has to be motion, sir, I can put in a motion. I mean, if that's what you need, I like to motion it. If somebody could second it.
Yeah, I understand that. We're still discussing it, and I think you've made your point on that 15% as well, and we've heard indirectly from, although I don't think that would constitute a vote, at least from texting from Jackie, that's there on the 15%. But let me ask this: if we approve the 15% as is being suggested by, was this going to be a 15% above the 6% that's done, so that it'll be a 21% increase total? Or 22 roughly?
I think is that 21, Kat? I think it's
No, I
because we
think we're
already
15%. It would be a total of 15 until such time, I think that's what we all agreed, it'd be making them whole at 15.
So we gave a 6% last year when the AG's office got 15%, right? And so
Correct.
we're trying to go back up to the 15%? Or are we doing it another 15%? So it's going to be 21% and the OAG increase was only 15%, because then that's going to create another wage war with
Yeah,
them.
we were looking at the entirety being 15%, and I think that we could be patient enough so that once the pay, I think that would be a great compromise, that when the pay study is done by DOA, then it'll bring it up to at least 21%. That was what DOA was talking about.
All right. So then, yeah, so I think we've got.
But let me can I just clarify, the AGs did get the 6% renewed. That was part of an amendment. So they're getting, so basically if we got 15% on top of, then we would be fine. But really at this point, it's just 9%. Because the legislature already authorized the 6%.
Okay, may I make a suggestion then? Why do we amend that section, say 50%, which will include the 9%, 6% that was passed by the legislature?
Yeah, that would be it.
That would resolve the situation.
Yeah, we're not trying to make more than them. We just want to make the same.
I just want to make sure. So
that was my concern too, because I agree with the CJ that I don't want to go through another, wage battle with the other government attorneys. So if we can just say 15%, which will include the 6% that was previously passed by the legislature.
When did the AG get that additional 6%, Steve? Because
it's a different appropriation where it was all the non-law enforcement were given an additional 6%. We're given a 6%.
You're talking about in this current budget, because we passed the 6% for all the attorneys last year, right?
Yes.
The board did. And so they got that 6% increase last year. And then but the AG's office only got 15% increase, right? That was their specialty pay versus the 6%. And so now, and then the legislature has since authorized another 6% for the PDs, which clearly is in that miscellaneous provision. So now we only need it beyond is to get up to the are we looking to get up to the 15%, or you're saying they added another 6% on top of the AG's 15%?
Yeah, no, just to get up to that 15%. So I think it would really be what the way the presiding explained it.
But I mean, we did 6% last year. AG's got 15. So this year we gave another, if we say we're gonna, give the full amount, because we haven't acted on the 6% yet, even though that authority is there. So if we just give the 9%, then that will bring us up to the 15% that the Attorney General got. Is that what you're saying?
No, there was another provision where they got across the board 6% increase.
In this budget cycle? Can someone point me to that language?
Yeah, that's what I'm trying to find it right now.
I mean, I just want to, because I don't want to get into another, and that I want to be clear of. I mean, when did the OAG get that additional 6%?
Yeah, so like Section 8 of Chapter 6. It's actually in their budget bill where it says the Office of the AG shall allocate a 6% increase in compensation for attorneys in the Office of the Attorney General for their fiscal year 2024 appropriations.
So a comparable one to the miscellaneous provision that we pointed out in our budget.
Yes. So yeah, so they got the 6% that we got, and then a 15% on top of that.
Mm-hmm.
So they had a 21%.
Yeah, they had a 21% increase.
So if our concern is to be in parity with the Attorney General or other government of Guam attorneys, I guess we just have the 15%, which will,
Include the amount already authorized by the legislature, the 6%. Right?
but will that catch you up with the Attorney General then? No, it
That,
won't, right?
that would catch us up.
Yes, it will.
Okay, so that's my amendment. 50%, which will include the 96% that was passed by the legislature, public law, whatever that is, huh?
All right, so you're asking that the resolved provision be amended to say adopt an approximate 15% increase, which includes the 6% increase from the miscellaneous provision in and I think it was the miscellaneous provision in section 31 of the public defender.
Just I'll give the authors the liberty to cite the proper statute. Huh?
Okay. All right. So
And does that have to be seconded?
Yes. Is there a second to that motion?
There is. Donna seconds it.
All right. It's a second. Now, also on the second whereas, is there a motion to make an amendment so it's clear that the pay disparity is between public defenders and other government attorneys, not just the prosecutors?
I'll make that amendment.
Okay.
All right, Christina
I can
Whitman has
second
made
it.
that, and Donna.
I can motion to adjust the second whereas clause to
All
ensure that there's parity.
All right. All right, so it's moved by Christiana and seconded by Donna Muñoz. Is there any other discussion on this resolution?
I move for the vote.
All right, PJ's moving for the vote. All those in favor say aye.
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 Those opposed? There's no opposition, and it
Subject to the amendments, right, Mr.
yes,
Chairman?
as amended, as amended.
Okay.
All right, then the next item is the above scale recruitment.
Yeah, sorry, that one so he actually accepted a job in New Mexico. So, but
Oh,
I'm gonna try to call him and change his mind after your vote. So, we might still have a shot at hiring him. So maybe if we want to consider it, and then, but
well, I think maybe we table it. I'm not going to vote on a above step recruitment when no one has,
accepted.
to
Okay.
accept. Yeah, I think with the process is when he accepts and we ask to solidify the requirement. So,
Okay, thank you.
all right. Is there anything else on our agenda? And our next meeting is the 28th of November at 12:30. And all right, everyone. So is there a motion to adjourn?
Move to adjourn.
Motion.
All right.
Second.
It's seconded. All those in favor?
Aye.
Aye.
All right.
Aye.
We now stand adjourned. Congratulations, attorneys,
Oh.
on your.
Before we adjourn, Mr. Chairman, can we, as a board, give our condolences to Steve on
Yes.
the passing of his mother and
Our deepest sympathies.
Yeah, Steve, of course, all of us have communicated with you and have indicated, and our heartfelt sympathies go out to you. Unfortunately, I will be unable to attend the funeral tomorrow, but Mary will be there representing me.
No, I know we all have work to do, but yeah, thank you.
No,
for
if I was on island, I would do it, but I'm at the Philippine Judges Association. Can't you tell by wearing my
the
barong?
barong.
Yeah,
Nice.
so I'm at the Philippine Judges Association
Oh.
annual meeting. I just flew in last night and I'm flying back tomorrow, but I had to be here to do a presentation today. And so.
Well, I just
All
wanted
right.
to, thank everyone for the support, and also on behalf of our lawyers here. I mean, thank God you guys were able to save us from, that little strategic mistake we made trying to rely on the senators.
Yeah. Well,
But,
next time, the best thing is, you come talk to PJ and I, because PJ's, spent numerous years in the legislature and has his experience. You can tell by his gray hair that he's got a lot of wealth of experience.
I worked for him for a couple summers. So
yeah, and so PJ's pretty astute when it comes to political affairs, and I think he could have cautioned about some of the potential pitfalls with proceeding in that manner. But where we're at, and I think, you know, we can stand on it and defend it and make clear why we had to do. And I think that, you know, the recent fact that we lost someone to another public defender's office, couldn't recruit him, that we lost a young attorney to private practice shows that, you know, if we're going to recruit and provide the competent indigent defense that our citizens deserve, that we've got to compensate our attorneys appropriately.
All right.
Your Honor, before we go, Jackie apologized to the entire board for not making it to the meeting, but she thanked
Tell her she has to buy us lunch the next time.
everyone. I'll let her know, but she apologized, but thank you. She also said thank you. for
LA
the-
traffic is, yeah.
Yeah.
All right.
Yeah,
Thank
adios,
you.
everyone.
Thank you.
She was, all right. Take care. Bye-bye.
Adios.
Thank you, bye.
Annyeonghaseyo. Bye from Korea.